A court in London has decided a Palestinian rights organization can challenge a government ban. UK authorities designated Palestine Action as a terrorist group last month, making it illegal for anyone to be a member or to display support for it. Dozens of demonstrators have been arrested for publicly backing the group. Charlie Angela reports from London.
The question in front of the judge was not whether the government's decision was lawful, but whether the High Court is the right place to challenge it. And the judge decided it is, on the basis that it contravenes freedom of expression under the Human Rights Act.
Not only were Palestine Action themselves never questioned or talked to about possible prescription, no single pro-Palestinian voice or pro-Palestinian organisation was ever consulted about the prescription, and yet they consulted the Israeli embassy.
This verdict will be deeply embarrassing for the government, and questions will be asked. Did it follow due process? Did it properly consult on whether or not this could impact civil liberties? Since the prescription on July 5th, 200 people have been arrested under the Terrorism Act, many of them for holding silent or peaceful protests, simply holding placards stating their support for Palestine Action.
For one group of people, the pro-Palestine activists, it's made us dig in. It's made us more determined. It's made us louder. And for another group, they are intimidated by this. The arrests that they have done so far, and there have been many, have been largely symbolic.
This is a landmark legal ruling, and it will allow Huda Amori, who's the co-founder of Palestine Action, to legally challenge the government's decision, but not until the end of November. The judge also ruled he won't be granting interim relief, which means for the hundreds of people who are planning to protest on August 9th in support of Palestine Action, they could still be risking arrest. Charlie Angela, Al Jazeera, London.
We're now going to speak to Laura O'Brien, who's the head of the protest team at Hodge, Jones and Allen Solicitors. She's usually based in London, but today, Laura, you're joining us from France. Thanks for your time. So you must be pleased with this decision. What stood out for you the most?
Well, I think that the first thing is that there's a proper opportunity for these points to be argued. As you've already said, this is by no means a victory in terms of the argument overall, but at least it gets to the next stage. What's interesting is the two grounds that the High Court have said are at least arguable. The first of those being that it's at least arguable that the prescription amounts to a disproportionate interference with freedom of expression and freedom to protest. And we have seen that played out in the arrests of hundreds of people over the last 3 or 4 weeks. And the other ground is that there was a failure to properly consult, a failure to consult at all with Miss Amori, and a failure in general to consult with any of the voices that would be opposing of prescription.
So what is it that happens next and we should be looking at, or you're going to be looking out for?
So my firm are not directly involved in the judicial review itself, but we are representing so far hundreds of people who've been arrested, and there is likely to be many more of our clients arrested in the coming weeks. So the short-term impact is what it means for our clients. And I think it's absolutely right. There are people who have decided, because they are opposed to the prescription, that they are going to go out onto the streets and protest. But we've got many more clients who are in fear, who've asked us, does that mean I cannot protest about Gaza at all, at a time when the situation is even more grave than it has been over the last few years, at a time where finally our government is starting to speak out and starting to recognise the gravity of the situation. And it's those people that we need to look out for and be advising and give some assurance to. But longer term, it's about where we are once we get to the end of this judicial review, whether the courts are able to stand up to the government. So often we've seen, particularly in relation to protest law over the last 5 years, that the courts have deferred to government. They've essentially said, well, government chooses how to use these powers as long as they follow the proper procedure. What's interesting here, going back to the grounds that the High Court has allowed the challenge to go forward on, is it's about process. It's about proper process. So fundamentally, the contents basis of the prescription, is it disproportionate interference with the right to protest? But have they followed the proper procedure in reaching this decision and only listening to the voices on one side of the debate?
Yeah, and speaking of that process, I mean, one of the striking elements in this case is that the UK government consulted only the Israeli government, but not Palestine Action. I mean, from a legal standpoint, how significant is that omission?
Well, the difficulty is that the prescription legislation doesn't include any obligation to consult at all. But if you are going to consult, to simply consult those you know will be in favour of prescription doesn't lead to an appearance, at least, of a fair process. And there is an argument that it's not just about consulting Ms. Amouri and those involved with Palestine Action directly, but many of the organisations who are specialised in subjects touching on freedom of expression and the right to protest, to not consult with any of those, but only to consult with those who've got a very particular interest in this topic, does mean that this is a flawed process altogether.
At the time of the ban, the Home Secretary Yvette Cooper said that violence and criminal damage have no place in legitimate protests, which, as you know, the government accuses the group of doing. But then the legal challenge argues that prescribing the group is a disproportionate interference with the right to protest. So I suppose the question is then, where should the line be drawn between national security concerns and civil liberties, in your opinion?
Well, let's be clear. Prescription is not about giving the police or the government a tool to criminalise people who cross the line. That already exists. There are already prosecutions where the government say, or prosecution authorities say, the line has been crossed. Prescription is not about that. It's not about whether or not you can prosecute people for their involvement in actions. It's about banning the organisation altogether. And more importantly, in what's led to the arrest that we've seen over the last few weeks, banning anyone arousing reasonable suspicion of being a member or supporter. So without any intent, without any involvement in causing damage, without any threat or suggestion of violence, simply holding a placard has led to people being arrested. That's what prescription is about. So it's not about giving the tools to criminalise those who cross the line. It's about the other people who aren't involved in that direct action being criminalised themselves, even for giving the appearance of support or membership.
Okay, we'll leave it there. Laura O'Brien, thank you so much for joining us this hour from France. Thank you.